what does planning look like for parents of kids with disabilities. And I don't like terribly the term special needs, but it's sort of a term that we've been given as lawyers to talk about things like special needs trust, or really talk about proactive planning for kids with disabilities. And so that's the verbiage that I'm going to use tonight. If you take offense to that, I'm sorry. I don't really like it either, but it's sort of one of those industry terms that it's kind of thrust upon us. But so tonight we're going to be talking about what does proactive planning look like? What do parents in your position do in planning ahead for a life after you? And so we're going to talk about trust. We're going to talk about ABLE accounts. We're going to talk about public benefits, what that looks like. And planning through uncertainty is really a key point to all of this. Is a lot of you probably just don't know where to begin, or that maybe your child is nuanced, right? You have a lot of things going on, and there isn't a one size fits all solution. And so you think, well, maybe there isn't a solution for me. And that's definitely not the right answer. There's always a solution for you. We're going to talk about two key solutions that you can utilize tonight. But the goal is really to just sort of demystify this, kind of give you the lay of the land. What is special needs planning? Why is it important? Why do parents in your position need to implement that sort of strategy, and what would it look like for you? And so I generally give a little bit of a rundown at the beginning of these presentations to sort of set your expectations, put some guardrails on the presentation. What is it supposed to do? What is it not? But at the end, you're going to have the opportunity to ask any sort of questions that you want. We'll leave this open to live Q&A at the end. I would estimate the presentation is probably going to be about 40 minutes or so. It's about how long it usually takes. Maybe a little bit shorter, maybe a little bit longer. But generally, if there's any questions you have, you can feel free to ask them whenever you want. Just understand we're going to hold the actual responses and the Q&A portion until the very end, just so that we can be respectful and effective in the presentation, efficient, and make sure that you get the information. And if you have to leave early, then go for it. Generally, this is not meant to be legal advice, right? This isn't an analysis of any number or any one of your circumstances. And if your questions aim at an analysis, if you're asking me to really give you advice, this isn't really the appropriate venue for that. If you're interested in having that conversation in a private venue, as opposed to a public venue like a webinar, we're going to include a link at the end that you can type that into your screen and book a call with us if you'd like. And we'll make that process really easy. And you'll see that at the very end. If you have any other questions about it, you can ask during the live Q&A. But again, I'm Paul Yocobytus. I'm an attorney with Carey Estate Planning. And I gave this presentation to a number of different organizations. We give it privately as part of marketing endeavors with our firm too. But it's meant to kind of give you the lay of the land. It's meant to be educational first and foremost. What does all this mean and why is it important? So with that said, I'm going to go ahead and share my screen and we'll go ahead and get started. And I'm going to hope that this works okay. Awesome. All right. So the presentation is called What Happens When I'm Gone? Special Needs Planning for North Carolina Parents. And while this is meant to be for North Carolina parents because I'm licensed in North Carolina and we practice in North Carolina, these concepts apply in pretty much every state. Every state follows the ABLE Act. Every state has special needs trusts. Every state has SSI and Medicaid and those sort of things. And so just know that we're licensed in North Carolina. This is meant for a North Carolina audience, as I'm sure that everyone here lives in North Carolina. As you can see at the bottom, we are predominantly located in Wake County, but we work with clients all over the state of North Carolina. And so if you don't find yourself in the triangle, don't feel bad. We don't exclude, right? We like to have honest, advisory conversations with anybody who's willing to take that time with us. And so if you have those questions, go ahead and drop them in the Q&A box and we'll address them at the end of the presentation. All right, let's clear off my desk so I can see the screen here. All right, so by attending this webinar tonight, you're going to discover a few things. You're going to discover that planning ahead for a child with special needs can be easy, but that most people just keep kicking the can down the road and they just never get the process started. They never engage in the conversation. You're going to discover that you can very easily and effectively make sure that your child's critical public benefits will be maintained regardless of what happens to you in the future. You're going to discover that you can take control of your child's future and appoint the right people to have the ability to take care of their needs with just a few proactive steps. And you're going to discover that even though your world revolves around the needs of your family, you also need to protect yourself from future uncertainty like disability, incapacity, and death. And when all of this is in place, you can finally attain the peace of mind and protection that you're seeking. So this webinar is for you if you're frustrated with all the misinformation and confusion surrounding special needs planning and the conflicting advice that you've been given by maybe family members or friends, neighbors, internet articles, Facebook groups or posts, Nextdoor posts, maybe financial advisors, maybe other lawyers you've worked with in the past. This is for you if you're worried about maintaining control over your child's affairs after they become a legal adult. This is for you if you're worried about making sure that your child's SSI, Medicaid, or other public benefits are protected if something happens to you. This is for you if you're worried about providing a future for your child where they will have the type of support that they need. And this is for you if you're interested in making sure that what you want to happen will happen, regardless of what the future has in store for you or your family. So I'm Paul Yocobytus. I'm a special needs planning lawyer with Carey Estate Planning, and I'm also a member of the board of directors for the Arc of the Triangle. For the last decade, our firm and myself, I've been focused on developing our expertise and skills in special needs legal planning, with emphasis on the creation of special needs trusts and helping families navigate the adult guardianship process. We've studied the regulations, we've taken the courses and the workshops, and recruited talented attorneys and support staff with backgrounds at Social Security and Disability Determination Services to help our team help families like yours. My journey to special needs planning began over a decade ago. My wife, Alex, is a master's level social worker. And for about 7 years prior to deciding to stay home to raise our kids, she was what's called an accredited disability representative through the Social Security Administration. And she helped families like yours apply for and receive SSI and Medicaid benefits through the application process and up to hearings in front of federal administrative law judges. So she actually appeared in court before I ever did. Now Alex actually works for our firm as our outreach coordinator, and she helps families research and find non-legal support and resources in our community. Having seen how difficult the public benefits process can be, I took it upon myself to help protect those vital benefits from future uncertainty. And I created Carey Estate Planning to help further that mission. So our focus is to provide guidance and certainty for families to know that life will be okay and to relieve parents of the anxiety of a life after them. So by the end of this presentation, my goal is for you to learn this one thing: how you can protect your child and their public benefit eligibility no matter what. And at the end, you'll have the opportunity to meet with one of our attorneys personally to discuss your particular needs if that's something that you want to do. But your ideal planning strategy will depend on your child's likelihood to work now and in the future. To start, it's important to understand what is special needs planning. Special needs planning is essentially at its core estate planning for parents that uses unique tools designed to help disabled beneficiaries maintain public benefit eligibility. Everyone needs estate planning, but parents of kids with disabilities need to make sure their planning is narrowly tailored for their specific needs. Special needs planning is aimed at assisting parents and families with planning for a life after the parents. There are generally two types of special needs planning strategies. First, we use special needs planning when a child has a disability that makes them eligible for government benefits like SSI and Medicaid, and the child needs those benefits for their support now and or in the future. So not just that they may be eligible for those benefits, but that they actually want and need the benefits themselves. Second, we use special needs planning when a child has a disability that does not make them eligible for government benefits, but we still want to make sure that someone else will be responsible for their financial care in the future because it may be inappropriate to allow the child to manage their own financial affairs. These two types of planning strategies can look pretty different, one more rigid and the other more flexible. And we'll jump into those distinctions a little bit later on. Not all families require a special needs trust, but all families need to create some form of special needs legal plan that will cater to their specific planning objectives. Special needs trusts are generally needed for the first variety of planning needs, that first type of strategy, when an individual meets the definition of disabled pursuant to federal regulations, which generally means that they are unable to maintain stable employment as a result of their impairments. And they must maintain eligibility for means-tested programs because of the support that they receive from those benefits, either now or in the future. And without a special needs trust, it's likely that even a modest inheritance will impact eligibility for means-tested benefits whenever you pass away. Special needs trusts are uniquely designed to maintain public means-tested benefits. But what does that mean, and what benefits may fall into that description? Generally speaking, public benefits will include means-tested federal programs like SSI, Medicaid, and Section 8, means-tested state-based programs like food stamps and North Carolina Special Assistance. But we're not planning for entitlement public benefits. We're not planning for things like SSDI or Medicare, and that's because they're not means-tested. They're entitlements because you paid into the system, or the parents paid into the system through their FICA contributions, through their payroll, right? It's important to also understand this little nuance about shifting from SSI to SSDI. It's a version of adult disabled child benefits that an adult disabled child who was determined to be disabled prior to age 21 will eventually shift from SSI and Medicaid to SSDI and Medicare, from means-tested benefit to entitlement benefit, when their natural parent, natural or adopted parent, draws on their own Social Security benefit, or after their parent or adopted parent passes away. However, that doesn't mean that we no longer need special needs trusts. There is a thing called dual eligibility for both Medicaid and Medicare. And so adult children who are on SSDI and Medicare will likely still need a special needs trust if they did shift over from SSI and Medicaid at one point, either because they'll need to maintain dual eligibility depending on their needs, or future Medicaid eligibility for skilled nursing or residential support services will be necessary. So special needs planning may still be needed, but it just depends on your specific needs now and in the future. Supplemental Security Income, or SSI, is essentially a monthly cash grant for food and shelter for individuals who are disabled, blind, or aged, which is defined as 65 or older. In 2020, the Social Security, the SSI federal maximum payment was $783 a month. That increased to $794 last year. We made a big jump because of inflation up to $841 this year. And next year is estimated to be $917 a month. And that's, I mean, they don't know yet. They haven't reported it. We only have July's inflation numbers. They generally will track 3 months of inflation before determining what next year's cost of living adjustment will be. But it's indicated if we keep this 9 or 9.1% inflation rate, that we should be in that $916, $917 a month range. That's another pretty substantial jump. In North Carolina, an award of SSI automatically grants you Medicaid benefits, although that's not the only basis for eligibility for Medicaid. Some of your kids may be on the innovations waiver, for instance. Special needs trusts allow you to essentially maintain the legal poverty of a beneficiary in the eyes of Social Security and Medicaid. We are planning ahead to keep your child legally poor to be able to comply with the required resource caps for assets and income. SSI and Medicaid are both means-tested programs, and so they require that a beneficiary of such programs have very limited means, very limited financial means. Medicaid also wants to be the medical care payer of last resort, so they want you to have exhausted your own means before relying on the Medicaid program itself. It's also why if you have a primary private insurance company and also have Medicaid, Medicaid is going to take the back seat, right? Or the last seat. Maybe you have two insurance companies. Because of this, SSI and Medicaid have established asset caps, or what they call countable resource limits, for eligibility for those programs. And assets are assessed on a monthly basis to make sure a beneficiary is not exceeding those caps. The countable resource limits for SSI have been for a very long time and still are $2,000 for an eligible individual and $3,000 for an eligible couple, meaning, both married spouses are SSI recipients. This is measured on a month-by-month basis on the first day of each month, and that's what we call the snapshot test. So your assets are going to be assessed on the first day of each month. And I say that these resource limits have been this way for a long time. We're talking decades, right? This hasn't had a cost of living adjustment like the SSI monthly benefit has. And it seems like as long as I've been doing this, which is about a decade, there's been a bill that's stalled out every single year in the Ways and Means Committee of the House that's seeking to adjust that threshold to $10,000, and it just won't go anywhere. It won't even leave the Ways and Means Committee. It's ridiculous. It's just not reality. Somebody just, has it out for SSI, I guess. So you may be wondering, okay, countable resources, well, what goes into that? Countable resources, it's actually defined inversely, or from the negative perspective. It's anything that's not non-countable or exempt. And so it's basically everything except, right? Exempt assets or non-countable assets will include things like your primary residence. So if an applicant for SSI or Medicaid owned a house, that house doesn't count against them as long as the equity in the house is less than $636,000. Now you may think, oh, that's great, I can leave my house to my child and there won't be any issues. Well, maybe, right? But if your child is then subject to a guardianship, then that means that the house is subject to the guardianship too. So it's not, just because it doesn't impact eligibility doesn't mean it doesn't have any unintended consequences of outright ownership. And of course, it may not be appropriate for a child to own a house outright, right? There's a lot that goes along with that. But of course, the SSI and Medicaid rules apply to any form of disability. And so, Medicaid is also relied on by elderly individuals who are seeking skilled nursing care. So these rules kind of apply to everybody the same way. They can also have one car. And you may think, well, my child doesn't need a car. Well, they can have one, right? Whether they need it or not, they can have one and it not count against them. And they can also have their personal effects and home furnishings and necessities of daily living. So like clothing and furniture, a computer, those sorts of things won't count against an applicant for SSI and Medicaid. So the everything else is a resource. So we're talking about real property other than the personal residence, or real property to the extent the equity exceeds $636,000. Every dollar above that would be counting towards that $2,000. A second vehicle, right? So if you have a primary car, secondary car, primary car, motorcycle, right? Doesn't matter. A second vehicle is countable. That's also why a lot of kids who are under 18 won't be eligible for SSI. And we'll talk about that a little bit more under the deemed resources tab. Life insurance policies that have a face value of $1,500 or more are countable. Cash, of course, is countable. Stocks, bonds, IRAs, 401ks, bank accounts, they're all countable. And it's essentially cash equivalents, things that can be made into cash quickly, or these second properties, second cars, right? And then there's this lovely concept called deemed resources, which is the reason why most kids under 18 will never qualify for SSI. Deemed resources are the resources of a spouse, a parent, or a parent's spouse, so a step parent. If a child under 18 lives with one parent, then $2,000 of the parent's total countable resources do not count against the child. If the child lives with two parents, then $3,000 does not count against the child. But SSI counts all amounts over the parent's limits as part of the child's $2,000 resource limit. And again, this is why that second car, if you have two parents and they each have a car, all it would take for that is for that car to be worth more than $5,000 and your child doesn't get SSI. It's as easy as that. And that doesn't take much, right? Deeming, or this application of someone else's resources against a child, doesn't stop until the month after the child turns 18. And that's also why most parents wait until after their child turns 18 to apply for SSI, not Medicaid. Now, there are other programs that will allow, or other basis for eligibility for Medicaid that are not resource-based, right? The Innovations Waiver is one of them. But deeming applies to SSI and to Medicaid to the extent you get it through SSI. And remember, step parent income and resources also apply. So it's not just the natural parent. So that can have an impact if a single parent is considering marriage, can have substantial impact on the child's SSI eligibility. When we're talking about special needs planning, remember, we're really just talking about estate planning with some unique planning tools, right? So let's take a look at those unique planning tools. They generally will fall into two different categories: trusts and able accounts. And we're going to talk specifically at the outset about special needs trusts. And then we're going to talk about a concept called a trigger trust later on. But from the special needs planning perspective, there are often, two different tools: special needs trust, able accounts. And it's important to understand that these are not contradictory. It's not, choose your tool. It's not one or the other. They're not opposites. We usually recommend creating planning strategies that involve the intentional use of both types of tools. And again, those tools are special needs trusts and able accounts. And so we're going to talk first about the able account, which is probably one of the two tools that most people understand the least about, because this is probably the most common question we get in this presentation and at consultations: how and when and do I use an able account? The able account is the newest planning tool, meaning it's been around only since 2014. It was created by the Achieving a Better Life Experience Act of 2014, also known as the ABLE Act. The ABLE account is a tax advantage savings account for individuals with disabilities and their families. The beneficiary is the account owner, and income earned by the account is not taxed. So this is a lot like a 529 college savings account, and it should be pretty similar, or seem pretty similar. And in fact, you'll see it is a 529A. So it's built on the same chassis, right? It's just used for different purposes. 529 college savings accounts are for qualified education expenses, whereas 529A accounts, ABLEs, are for qualified disability expenses, but they fall under the same regime of the IRS code, right? The tax advantage growth, the types of investments it can hold, those sorts of things. But again, no income, no capital gains tax that grows tax-free. And contributions can be made by any person, but they're not tax deductible. ABLE accounts were an access to savings initiative. So they were created to increase access to ways to save funds without affecting eligibility for SSI, Medicaid, and other public means tested benefits. They're meant to secure funding. This is a quote from the actual bill. Secure funding for disability related expenses on behalf of designated beneficiaries with disabilities that will supplement but not supplant public benefits, meaning use of the assets in a way that doesn't replace the utility of the public benefits itself. Perfect example: you can't use an ABLE account to pay for health expenses that Medicaid otherwise is supposed to pay for, right? That would be supplanting the benefit. The upside, I like to do these pros and cons when we're talking about these tools, right? The upside of an ABLE account is that it can be self-funded. It is a first-party tool. First party meaning the beneficiary's own money can be used to create and fund these accounts. It doesn't have to be a third party, right? This is a non-countable resource as long as we play by the rules, right? The dollars or the value of the account, as long as we play by the rules, and I'll talk about the rules in a second, doesn't count against the child or the beneficiary for the purposes of those $2,000 resource caps. The beneficiary, if it's appropriate, can manage the funds in their own ABLE account, making them less reliant on others for assistance if it's not needed, right? That's obviously not appropriate for everybody, but to the extent your child can actually manage their own financial affairs to some extent, they can be in charge of their own ABLE account. And some of them have debit cards, so they can actually go buy groceries and those sorts of things. The funds in these sorts of accounts, just like a 529, are going to grow tax-free, and they're not subject to gift tax, income, or capital gains tax. They are generally considered to be easy to set up through local financial institutions, like a 529 college savings account, but they're not as widely available. Generally, states pick funding partners or banking vendors to work with. So not every bank has them like a 529 college savings account would. You generally can start with the North Carolina Treasurer's Office website and then set up the account through an approved banking vendor. You can also go to savewithable.com/NC for more information. Now, in the triangle, often the banking vendor has been Fifth Third Bank, but I've had a couple clients tell me they've actually set these up through PNC Bank. I haven't done it personally because I'm not eligible on either of my kids, but that's generally the feedback that I've been given. It's been primarily Fifth Third Bank with a couple families using PNC. The downside, right? The cons of the ABLE account, and I need to adjust this slide because it's 16 grand now, but the ABLE account right now, there's a bill pending to adjust this age, but right now it's only available for individuals who developed their disabilities before turning 26 years old. So it's not really going to be appropriate for anybody who became disabled later in life or who was deemed to be disabled. They were given an award of disability later in life, right? This sort of account does not provide protection for the beneficiary from potential predators, right? So we talked about autonomy, the ability to coordinate your own affairs with the ABLE account, the debit card, those sort of things. But with that autonomy comes the other side of the same coin, the potential for predators, people to take advantage of your child, right? If they have access to money, somebody may use that to their advantage or try to take advantage of your child to get access to that money too. The contributions to these accounts are limited. And again, I didn't update this slide today before I did this presentation. It is supposed to say $16,000 per year is the contribution limit, and it's actually tied to the annual gift exemption. So as that gift exemption goes up, so does the annual contribution limit. But one thing that hasn't changed as we went from 15 to 16 per year is the aggregate total amount. You can still only hold up to $100,000 in this account, not a dollar more. Every dollar more than that on a yearly or total basis does count against the $2,000. So in ABLE account, when we talk about like, what do we use ABLE accounts for? Why are they important? How are they helpful? ABLE accounts are really more suitable as a tool for cash flow management rather than as an inheritance or wealth transfer tool, right? What I mean by that is sheltering smaller sums of countable cash. So we just talked about next year's SSI limit could be over $900. And when the resource cap is $2,000, all it takes is a little over 2 months of not spending any of that SSI money, assuming your child gets the full benefit, federal benefit rate, to be real close to that $2,000 or over it. And so we can use an ABLE account as a little bit of a sweep account. We can set a lower threshold, say like, well, if the bank account gets up to $1,700, we'll move $200 into the ABLE account or something like that, right? So you can just have this secure, non-countable savings account that can be the receptacle of those excess funds, so it doesn't penalize your child, so it doesn't disturb their benefits. Without the assistance of someone who actually knows what they're doing, an actual special needs planner, use of an ABLE account could still affect government assistance, and that would be by spending money on inappropriate expenses or overfunding or not paying attention, as you're making these contributions, those sort of things. Another pretty significant downside is that ABLE accounts can only hold cash and very limited forms of securities, usually going to be index funds or mutual funds. Can't hold tangible property, real property, business interests, anything like that. And then probably the biggest downside is that it does have a Medicaid payback provision. And so we want to be careful contributing excess funds to the extent that we're not confident we're going to spend them down. Because if something does happen and your child passes away and there's a balance remaining in that ABLE account, after costs of their administration and final resting place are paid, every dollar has to be paid back to Medicaid to meet their obligation, right? To pay back the lien that Medicaid has issued against the estate. The second type of tool we're going to talk about is the special needs trust. And this is probably the more popular or well-known type of tool in special needs planning. While special needs trusts fall into three main categories, they are generally for the sole purpose of protecting a beneficiary's government benefits from assets they are receiving. It allows you to protect assets from mismanagement or misuse. It allows you to appoint a trustee or a series of trustees who will manage and administer the trust for the benefit of your child. It allows you to protect benefits by keeping assets out of reach from the beneficiary from a legal perspective. It allows you to provide supplemental support over and above what the benefits provide for. And it can hold literally any type of asset. There is no asset limits. There are no asset restrictions. But this type of trust is not your average trust. And this cannot be stressed enough. The average trust will not work. It will, without a doubt, eliminate eligibility for means-tested benefits if you do pass away. Third-party trusts are usually the type that are going to be created by a parent or a grandparent. That person is called the grantor. The source of funds, this is why we call it a third-party trust, is the money comes from anybody but the beneficiary, so any third party. And it can be contributed during the life of the grantor, which is appropriate in some senses, but it's pretty limited application when it's a third-party trust. Or it can be funded at the grantor's death or the death of any third party through things like life insurance, estate assets, retirement assets. Could be funded through a will, right? The grantor, the creator of the trust, is going to choose the trustee, and that trustee can be anybody but the beneficiary, right? Beneficiaries can't be their own trustee because it merges the roles, right? It's basically saying they actually have control. The grantor also gets to choose the remainder beneficiaries. Should something happen to the primary beneficiary, the remaining balance of the trust does not have to be paid back to Medicaid. It gets to instead be given to whoever else you want. So it could be the other children in your family. It could be other family members generally, or it could be a charity, nonprofit, any number of different individuals or entities, but not Medicaid, not the government, right? The trustee of this type of trust, what makes it different from a traditional trust is their absolute discretion to determine what's supposed to happen with the money in the trust. They can withhold distributions whenever they want, and they cannot give money directly to the beneficiary. Those are hallmarks of a special needs trust. No ability to force the trustee to compel a distribution, and no ability to give money directly to the beneficiary. And these sorts of trusts can be revocable during your lifetime, which is really important, right? What happens if your trustee order needs to change because somebody passed away or because you change your mind? Any number of different reasons. If it's irrevocable, you can't change the trust as easily. What happens if you want to change the remainder beneficiaries? Well, if it's irrevocable, you can't do that, right? So revocable trusts allow for some more flexibility, and it could be even that a disability is resolved, or the purpose of the trust is no longer satisfied, or something happened to your child before something happened to you, right? We don't really need it anymore then, but revocability allows for some more control. And for anybody who's watching who has a special needs trust in place that was either created before 2016, which is before ABLE was actually in place and enacted, or was created by a lawyer who was not a special needs planning lawyer, you should have that trust reviewed to make sure it's actually doing what you want it to. We review special needs trusts all the time that have issues, and they would cause some unintended consequences if the parents who created them did pass away. It's not your fault. It's not their fault. It's that somebody decided to dabble. They don't know what they're doing. They just have a template, right? That's why it's important to know who you're working with. But what happens if you don't need a special needs trust? What if your child is not likely to qualify for means tested benefits? They have a disability. They probably don't need to have money in their own name, right? But they probably will not qualify for means tested benefits because they work too much or because they're able to support themselves in some way. When the future benefit eligibility of a child is uncertain or not likely, but the child will still need someone else to manage money and financial support for them, the solution is what we call a trigger trust. It's a family trust with special needs triggers built in. A trigger trust is a revocable trust, allowing total flexibility and control while you're alive and protection for all children after you have passed, or all heirs, all beneficiaries, whoever you choose to benefit. You can change the trust terms and contribute or withdraw assets from the trust whenever you'd like. It essentially acts as your overall estate planning solution. Unlike a special needs trust, which requires a single primary beneficiary, a trigger trust can benefit as many children or beneficiaries as you'd like, while treating your child who has disabilities with extra protection and control if needed for the rest of their life. It can also allow for more flexibility, like giving small amounts of money to the child directly if appropriate, which is not possible in a special needs trust. The trigger trust is designed to replace your monetary support, to supplement the resources the child is otherwise receiving, if any. But probably most importantly, the trust becomes irrevocable at your death. So it's out of reach for many third parties like potential creditors or predators, or people who may seek to take advantage of your child. So with special needs trusts and trigger trusts, there's a planning solution for everyone. So no matter what your circumstances may be or how uncertain your child's future is, there's a solution for you. But you can't just do nothing, right? It's really easy for parents when presented with all this information to be paralyzed by analysis and to get lost in the weeds. But doing anything is better than doing nothing. So taking the first step is better than standing still, because unfortunately, tomorrow is not guaranteed for anyone. The good news is that your plan is within reach, and with it, you can protect your child and their public benefits no matter what. But you may be wondering, how do I make that happen? So our process at Carey Estate Planning starts with scheduling a complimentary 15-minute discovery call with our client intake specialist, Sarah Corman, to go over your planning objectives and our process to see if it's a good fit, if we can help you in accomplishing your special needs planning goals. If you visit careyestatePlanning.com/call, you'll be able to access our calendar directly to book your complimentary 15-minute discovery call with Sarah. If after your call, we determine that we are in fact able to help you, Sarah will assist you in scheduling your initial strategy meeting with one of our attorneys to go over your specific needs and recommend a course of action to create your ideal planning strategy. And so that first step, all you've got to do to get that process started is visit that link, careyestatePlanning.com/call, and book that call whenever it's convenient for you. Now, this was a lot of information. So here's your opportunity. What questions do you have? And keep in mind, it's meant to be educational. It's not meant to be analysis, right? If you have high-level questions, happy to answer them, though. And I think there's one question, Meg T. This is such a great question. Are supplemental needs trusts and special needs trusts the same thing? Generally, yes, but they're different terms for different types of special needs trusts, right? So we use the term special needs trust as sort of an umbrella term around Social Security and Medicaid compliant trusts. More specifically, the third-party variety is called a supplemental needs trust, meaning the parent or grandparent, the third party, is supplementing the needs of the beneficiary in addition to the public benefits they're receiving. Special needs trusts are generally considered to be first-party trusts. Those are ones that are irrevocable, have Medicaid payback provisions, and are self-funded, and they're more rare. They're more of the oh crap, we've got to fix a problem type of trusts, or we got a personal injury settlement from a car accident or an abuse case or those sort of things, and that money is otherwise going to count against the child for benefit eligibility. What's the difference between a third-party trust and a special needs trust? I think I just answered that. If you want some more clarification, you can follow up on that question. But generally, third-party trusts are the type that parents create. This is part of an overall estate planning strategy. First-party trusts are the type that we create to shelter assets that we were not expecting or that we should not have received outright, either through an inheritance from lack of planning, for a personal injury settlement, or some type of gift that was in excess of accountable resource thresholds. So for instance, I often will represent families where a child is unfortunately abused by a teacher or a school employee. I have a really good friend named Stacy Gayhagen who works in education law, and she sues those school districts, and she wins most of the time. Now, that's not a guarantee. You know, if you have an issue with that, obviously she's the person to go to, but those will net a settlement, right? There will be tens, if not hundreds of thousands of dollars generated from that type of settlement or award, right? And so if the child is already on means tested public benefits, the award itself will disqualify them. And so the way to protect the child's benefits from that lump sum settlement or that gift is to move it into a first party trust and have the judge assign that benefit to the trust so that it's not actually received by the beneficiary. That's what we use first party trusts for most often. We will also use them for adult disabled kids who accumulated some wealth over their lifetime. Not substantial wealth, but maybe $50,000, $60,000. Maybe they worked a little bit, or they just are really good savers from when grandma and grandpa give them money. And then they get to 18 and parents realize, oh, we should probably be applying for public benefits, but 50,000 is 48,000 too much. It's also far too much to fund into an ABLE account. I can't do that quick math, but I'm a lawyer, right? So you can use a first party trust to basically put the money into that trust and it not count against the person when they go to apply for SSI. Those are generally why you use first party trusts, but they're really restrictive. They are irrevocable upon creation, and they have to pay Medicaid back. That's sort of the grand bargain. Medicaid will let you keep that money in this trust, but if there's anything left, it has to be paid back to Medicaid after the beneficiary passes. Ellen, can you tell me the difference between general guardianship and guardianship of the person, how they could affect the estate, et cetera? Yeah. So there's actually 3 types of guardianship in North Carolina, and in some other states we call this conservatorship, but North Carolina calls it guardianship. So the first, you mentioned guardian of the person. That is the care, custody, control, medical decisions, the caretaker from a legal perspective for an adult disabled child. They're called the ward under guardianship. That does not give you money authority, does not give you property authority. Guardian of the estate gives you money and property authority. That also requires that you be bonded by a surety company to ensure the value of the estate, but that allows you to manage the money, whether that's income or assets of a ward, somebody under guardianship. When you establish both guardian of the person and guardian of the estate, those together are called general guardianship, right? General is of both sides. Guardian of the estate and general guardian have to account to the clerk that issued or opened the guardianship file every year for all of the financial transactions and affairs of the guardianship each year, right? It's called an annual accounting. And you're basically submitting or you're asking for an approval of the things that you've been doing, right? And that's also why we get surety bonds for general guardians or guardians of the estate. The bond is meant to protect the beneficiary or the guardian from their guardian, right? Or I'm sorry, the ward from their guardian. If somebody just takes all that money and runs, there's an insurance policy that protects that benefit. How they could affect the state, right? We don't want to leave money outright to a child who's under guardianship, because then it becomes part of their guardianship, and it also then becomes countable against them for public benefit resource or public benefit resource caps. That's why trusts exist, right? To to essentially allow total control over wealth transfer after you're gone, right? If you don't give it to a child directly, it can't be part of their guardianship. You mentioned innovations waiver. Why is there such a backlog for the state giving the waivers? Can we do anything about it? You live in North Carolina, right? We do not, as a state, favor Medicaid, right? We don't fund it appropriately. We did not do Medicaid expansion when I think 39 states did. We didn't. And this is very much, and this is not a political thing. I would imagine you probably don't care what my political lean is, but this is a red state, blue state problem, right? I mean, if you go to California, Pennsylvania, New Jersey, New York, any of those blue states in the Northeast, they don't have problems with this. North Carolina, South Carolina, Arkansas, all these red states, they underfund Medicaid. It's just categorically across the board. And so that's why there's such a backlog. That's why there's such a long waiting list, is we don't, as a state, as a legislature, care about Medicaid enough to provide enough resources to it. Is there anything you can do about it? Write your congressman, right? Write your legislature. Annette, when should you start funding a supplemental needs trust? What reports will that trigger? So generally speaking, it depends on the type of trust, and it depends on the type of assets and the goals, right? So I generally don't recommend funding special needs trust, supplemental needs trust until you die. That it's when is the actual support needed? When does that beneficiary need to start actually receiving support from that trust? And during your lifetime as the parent, it's probably not until you pass away, because you yourself are going to provide that support directly, and you yourself doing that is not subject to Medicaid review. They can't look at your money. They can't peer back the curtain on your checkbook, right? And so it's generally restrictionless holding when it's in your accounts. But when you pass away, as long as it's funded into that supplemental needs trust, it's then not going to count against them either, right? What reports will that trigger? Generally, when a trust is funded, it is subject to audit, right? Audit by the Medicaid Review Board. Generally speaking, you can have that audit done whenever you want. You can have trusts pre-approved if you'd like, right? But generally, there has to be a pretty good reason to fund a supplemental needs trust ahead of time. When it's revocable, it's as if you own it yourself anyway, right? So a lot of times, our firm creates revocable supplemental needs trust so that the parent can maintain total control until they die. Change the provisions, remove trust protectors, trust advisory committee members, replace trustees, all those important things that you kind of don't think about when you actually create the trust. But the downside of it being revocable is it's as if you own it yourself when you're the grantor, because you have the right to withdraw that money whenever you want, right? So for taxes, for liability, for creditor attachment, it's treated as if you own it yourself. So if that's the case, what's the point of funding it, right? You might as well just keep it in your own accounts. Because what if you need it? What if you have a health crisis? What if you need assisted living or skilled nursing yourself? You can't necessarily pull it back as easy if you're incapacitated or those sorts of things. So generally, fund it when it's appropriate, which is usually going to be after you're gone, when that actual financial support is needed. All right, Meg, to clarify, ABLE accounts are protected from the income limits for benefits, right? So if I have supplemental needs trust for my daughter, but we need to give her an account that she can use for day-to-day expenses, is an ABLE account the right way to go? Or is it better to manage under the $2,000 limit with a regular old account and just stay on top of it? Is your daughter already on public benefits? Are they receiving SSI and Medicaid? Is that a pretty solid likelihood if not? The downside of an ABLE is obviously that it's restrictive in its administration. It can only be used for qualified disability expenses, and it does have the Medicaid payback. So if a child is not on public benefits, we don't generally recommend setting up and funding an ABLE unless it's really certain or pretty certain that that's a future likelihood, right? But yes, you're correct. Up to $16,000 per year, ABLE accounts don't count against the beneficiary, but it has to be used within those contribution limits and only for qualified disability expenses. And if you're questioning, well, what is that? Google it. 529 qualified disability expenses. there's a pretty solid overlap between what you can use an ABLE account for and what you can use a special needs trust for. If you use just a regular old account, it presumes a few things: that it's okay for your daughter to own money outright, that that's not a problem, that doesn't have risks associated with it, and that, you know, staying on top of it. Well, what does that look like? Well, without an ABLE, it means spending money. It means spending it down, you know, using that money for her benefit, because if you just move it out into your name, that's going to be a penalized transfer. It's going to be Medicaid seeing that as you know, gifting money to yourself from your daughter's account. So we got to be careful. It's a little bit of a minefield, right? It's unfortunately an onerous set of regulations. Does your personal trust direct your estate funds, properties into third-party trust? And is the third-party trust set up prior, i.e. small amount to open third-party trust? It depends, right? It depends on the trust, its use within your overall estate planning strategy. And so some people use two trusts, a family trust and a third-party trust. And that's really if you've got the need for that, right? For probate avoidance, for managing money for other children who are more neurotypical or developmentally typical kids that don't have special needs considerations, that's pretty common, right? We can have a family trust that's more age-based, more maturity-based, and then a third-party trust that's really just narrowly tailored for a specific child, right? For their specific benefit adherence needs. Other times, we just have a will plan that funds the special needs trust or the third-party trust instead of giving money directly to the child. So it's sort of like bubble wrap, or like a nice little brick wall around the child from receiving benefits outright. But that's also where we're going to plug on retirement accounts, beneficiary designations on life insurance, IRAs, 401ks. Think of the third-party trust not as like this overall umbrella estate plan itself. Think about it as a substitute for the child as an individual, right? The child is the beneficiary of the trust instead. The trust becomes the heir. It's who you name in the will, you name in the family trust, you name it on beneficiary designations across the board, that sort of thing, right? You don't have to fund it at all during your lifetime. You just have to have an intention to fund it. So it can be beneficiary designated, named in another trust, or named in a will, and it's valid, right? It doesn't have to hold any money at all. And you don't have to get an EIN for it either. If it's revocable, you can use your own social security number to, you know, establish its accounts. Let's see. Vicky, young adult is on SSDI, has Medicaid/Medicare, and on mom's health insurance, first payer. Independent, still active, not under a guardianship. Not looking at ABLE account. Special needs trust with sibling being the person to handle once I am gone. Can I leave that trust once my child passes away to her siblings' children? Yes, absolutely. Yep. And you can build out that bench too and sort of say, well, if not them, then a charity, or if not them, then another relative. You can put in through conditional logic a lot of different scenarios: plan A, plan B, plan C, plan D, as far as you think is reasonable. And the beauty of revocable trusts is you can change that whenever you want. So if the siblings' children end up, you know, being ne'er-do-wells, you can hold it a little bit more specifically, right? Or if they have a drug addiction or something like that, you can change the way things are administered, not cutting them out, but changing how they benefit so you're not feeding an addiction or something like that. Young adult works a 16 hours a week job. She's on SSD, I assume, because you're drawing Social Security, or her other parent is passed away. That's why, you know, you would generally shift over to SSDI. Father retired. Okay, got it. Yep. Yeah. So that's the big thing is, you know, Medicare and mom's health insurance are probably going to pick up the bills primarily for a long time, right? Mom's health insurance goes away at some point. She either retires or she passes away. Then Medicare is going to carry the heavy lifting for the day-to-day medical stuff, the doctor's visits, the hospital visits, and those sort of things. But Medicaid is really going to be that payer of last resort over and above Medicare. But the primary provider of things like assisted living, group home payments, those sort of things. Unfortunately, Medicare doesn't pay for those sort of things. Meg, she has Medicaid now. Planning ahead, she's only 7. Yeah, so I mean, it's probably appropriate to set up an ABLE account. The ABLE should probably not be funded yet, though, because you can just hold that money instead unless you're going to use it as like a spillover account, right? But is she receiving SSI or any real source of income? Or are you really thinking about like once she turns 18 kind of thing? Thank you for when she, yeah, I mean, you got time. The reality of it is you want to do it before 18, especially if it's really clear that they're either already on benefits, like your daughter has Medicaid, right? So that means she's already been determined to be disabled, right? So the second part of the calculus is just maintaining poverty. And so unless there's a substantial change in her circumstances, she probably won't have her disability flipped, right? It won't be a secondary determination that she's no longer disabled later in life. Obviously, you never know. I actually just had a client whose son was reversed the other day because he works 15 hours a week, and his disability was reviewed and they determined that he's no longer disabled. Like, you're kidding, right? It's like my wife's former employer, her name's Kim Engler. She works for Disability Advocates Group. First time she's ever seen that happen. So it's not necessarily like rules are the same forever, but generally you got to think of like what would be the upside of putting money in the ABLE now, right? Especially because as a 7-year-old, she probably doesn't need walking around money. She probably doesn't need like a debit card to sort of buy her own things. But your money or something like Medicaid doesn't count against her, and you can use it for her benefit. Medicaid obviously isn't paying income either. So the ABLE account, I think for you is really, like you said, thinking ahead, planning ahead. You definitely want to put it in place while she's a minor, because mom and dad have all the control during minority, but you magically lose that control at 18 unless you set up guardianship, or unless your child gives you power of attorney to coordinate their affairs, right? Those are generally your options at 18 if you feel that it's appropriate to still have some input into decision making. Not everyone's appropriate for guardianship, and some people. I've had a client that you all probably know very well, who is a very frequent speaker in the area and is a self-advocate, and he started out at 18 under guardianship, and then a couple of years later our firm helped reestablish competency because it was really clear that it probably wasn't appropriate. And after competency was reestablished, we then did powers of attorney to allow mom and dad to still be able to make medical decisions if he became incapacitated, and to be in on financial transactions, help him manage money, those sorts of things. And so keep that in mind. Obviously, this is fluid, or it's not all one size fits all either. What was I going to say? You definitely want to do as much as you can in terms of proactive planning while you can, right? A lot of people, when their child is 7, not picking on you, Meg, but as an example, they think, well, I've got time. I don't really need to do anything yet, right? Planning proactively is one thing. Funding and implementing is another, right? Special needs planning is something that you need to start as soon as you can, because of course, COVID and those sorts of things just kind of showed us that our mortality is a little bit more fresh and right in front of us than we realized. And so we never know when our time is up. First party trusts are needed when mom and dad didn't plan, right? When intestacy gave the money directly to the child, and that's what we want to prevent. But when, in terms of your question specifically, getting that ABLE account set up will be important during her minority. And you generally have to fund it with a minimal deposit, but it doesn't mean you have to start contributing money to it. And you may not want to, right? Because it may impact, her ability to fund it more thoroughly later on. If she inadvertently receives an inheritance from grandma and grandpa worth 15 grand, and you had already contributed $2,000 or $3,000 into the account in that year, she can't spend that entire amount by putting it into the ABLE account and sheltering it. So it's sort of that unintended stuff that it's better safe than sorry sometimes. Annette, encourage applying for SSI at 18. If parent dies and child gets SSI, there will be a spend down. If child has SSI, Social Security will not trigger spend down. Yeah. And also, if a child is deemed disabled prior to 21, that's what triggers that SSI or SSDI flip over. If they're not deemed to be disabled or awarded disability until after 21, then they don't get that switch over. We're always talking about means tested public benefits. You don't switch over to entitlements. So that timeline is pretty important. Now, it's generally going to be like retroactive to application date, or whenever the date of onset is determined by Social Security. It's not necessarily date of award. It's whatever the award says is date of onset. So getting the ball rolling is important prior to 21. But if you submitted the application for SSI the day before they turn 21, that's not defective, or the day after, if the award says they've been disabled since prior to 21, right? That's what's important. Let's see. We have to wait another year for our 19-year-old son gets Medicare. We also need Medicaid, but have not been able to get it. I want it to be secondary for housing costs, etc. Should we wait until we get the Medicare first before we pursue, again, Medicaid? So are you getting Medicare because you're retiring, like through this adult disabled child benefit? Yeah, but did you just retire? Because there's like a 2-year phase over for Medicare. Oh, okay. Well, I'm not tracking your Medicare question then. But generally, Medicaid and Medicare are going to have different bases for eligibility. I don't see there a good reason for why you would wait if you think Medicaid is going to be needed in the short term and not waiting, a year. Does your child have SSI? Got it. Have you applied for SSI? He's 19. He's not eligible for SSI, but he has a disabled adult child. Okay, and what is his monthly benefit rate? Got it. Yep. Okay. Yes, that all makes sense. Yes, you have another year because it's a 2-year phase over on Medicare. The application for Medicaid, go ahead and submit it. I mean, it can't hurt. If you're denied, you can still apply again later if you feel like there's a reason to. Yeah, they're correct. You're not eligible for SSI if you're already on disabled adult child. I misread that. What else? Any other questions? Obviously, don't want to keep everybody here all night. I know it's already 8:30. Yeah, Vince hit the nail on the head. Yeah. And that's what I'm referring to as it has to be a child who's deemed to have been disabled prior to age 21. If the child is deemed to be disabled after 21, then they don't get your Social Security benefit at all. They stay on SSI. Any other questions, thoughts, concerns? I'm going to quit sharing my screen here and just go primary screen here.
Well, it looks like we're winding down. Paul, that was fabulous. Thank you very much for your time.
Absolutely.
Your links will be live in the PDF of your PowerPoint. That's a question. Will your links be live in the PowerPoint presentation?
I think so.
Okay. All right.
Question.
I will be following up next week with the survey for tonight's presentation, the PowerPoint, and the recording. And I would also like to remind everyone, since I am the Advocacy and Outreach Director, there is a lot going on that affects our children, whether we're talking about the age limit for ABLE accounts, whether we're talking about funding for the innovations waiver, whether we're talking about the marriage penalty for people with disabilities or the asset limit. So I will try to send some links to how you can try to help move the needle on some of those things. But for tonight, I would just like to thank Paul once again and thank everyone for joining us this evening. And hopefully we will see you again. For those of you with little ones, next month's virtual presentation is on ditching the diapers. So that's always a very powerful presentation. All right. Well, again, Paul, thank you very much. And thank you everyone else for joining us this evening. Take care.
Bye-bye.
Thank you.